The new 8.0 multi-board contract. For those of you that are in the Chicagoland area, you're going to stay back and hear this valuable information. For those of you that are outside of Chicagoland, Central, Southern Illinois, out in the Quad Cities, we appreciate you having been here today. Unless you're interested in our contract in Chicagoland, really no reason for you to hang back. But again, for those of you that are in the greater Chicagoland area today, I'm checking to see if Adam is here. And if Adam's here, if you want to give a... So, who do we have to thank to have Adam in here? I'm not sure if Tim is here today. But Adam Wilde comes here courtesy of Tim Wheeler, our local account executive at Chicago Title. And Tim, if you're here, you want to unmute yourself and say hi. If not, we're going to jump right into it. Wasn't sure when it was going to happen, but Tim, many of you have probably met in some of our in-person events. They've been a very great partner of ours in Chicagoland. They have a really fantastic app that does net sheets. So download the Chicago Title One app, and if you need it, put in Tim Wheeler as your account executive name. Again, we've consulted and talked about this, that you should be doing net sheets. You should be submitting net sheets to your seller with every offer. Should you be submitting net sheets with every counter offer to your seller? Absolutely, right? They're quick, they're easy to do on most of your on the apps that are out there. But ultimately, long and the short of it is Adam Wilde is here to talk about the new multi-board. And Adam, if you're going to introduce yourself, I'm going to turn off my presentation so that you can take over the screen. And Adam is Adam, if you're here, you want to unmute yourself.
I'm here. Can you hear me okay?
Yes, we can. All right. Oh, and Tim's here too. Tim, if you want to unmute yourself, say hi, or oh, you can introduce Adam. Ha ha ha.
Well, I'm not sure if can you guys hear me at all?
Yeah, I can hear you, Tim. Hi.
Perfect. Steve, thank you so much. And for everybody here, I appreciate you guys taking the time. And I love the fact that EXP promotes Chicago Titles so much. We always talk about the Chicago Agent One app. I know there's a ton of EXP folks on it. Any question that ever, just let me know. I'm here to help you guys as much as possible. And I'm super excited for Adam to be in front of you guys today. I work with lots and lots of real estate attorneys every single day. And Adam is at the top of that list for sure in terms of his knowledge and ability. And I'm super excited for him to talk to you guys about the 8.0 contract and fill you guys in on what's going on. So that's all I got.
And Adam, so for you to share your presentation, you hit the little button at the top of the yellow stars and select streaming screen.
Sure. I'm going to drop the link in too, so if anybody wants to access it on their own screen, but I'm going to hit the star button now and streaming screen.
Yes. And then hit share screen there on the right.
I got you. We're here.
Wow. Thank you for sharing that. I didn't know we were going to share the presentation as well. That's cool. I appreciate that. That's fantastic.
I'm going to share
again. Best practice is to zoom as soon as he gets it. Best practice again, click on the center screen to zoom in on it. And then Adam, I'll monitor the chat box. Again, it's important to know you're here to ask questions. You can unmute yourself and ask Adam questions as well about the contract in general, not just the changes. I'll continue to monitor the chat box. If there are questions in the chat, I do now have a comment in the chat box that's a bit hard to hear you, Adam. So if you want to yell into your headset or talk closer to the laptop or however we're going to do it, that would be fantastic. But Adam, take it away. Appreciate you being here.
No problem. I hope everybody can hear me now and everyone can see my screen share. Kind of run through this with you guys for the multi-board 8.0. Give you a quick background of it, and that's just me. For those of you that haven't met me, really short background. I've been practicing now. I'm 15 years in. Tim's saying it's still hard to hear. Can't hear him at all.
Yeah, if you're on a laptop and you're not using a headset, sometimes you have to lean kind of closer into your screen because the microphone's there at the top. But some of it. But also, if you can kind of increase your volume, some of you can hear, some of you can't. We're definitely going to drop this in later.
Okay. Yeah. How's that?
Yeah, just keep moving along. Some you can hear, some can't. But
so as Tim kind of introduced me, I've been practicing now for 15 years. I started my firm in 2018 after working for a very large foreclosure firm. And since 2018 being on my own, I've done over 5,000 real estate transactions. For those of you that don't know or haven't heard of IRELA, IRELA is the Illinois Real Estate Lawyers Association, and it's very similar to the associations that you guys are members of or part of, but it's to represent attorneys, and I am the vice president of that. So my contact info is here. If any of you have questions, we'll drop it in the chat. We'll have a follow-up, but I'm happy to answer any questions you have now or afterward. My practice areas are pretty real estate centric. Do a lot of real estate transactions. I represent a lot of landlords, property managers, etc. And then I do a lot of estate planning and represent small businesses. So a lot of small businesses that are in need to create LLCs, we do that as well. That's just a really simple background, and I want to go into the nuts and bolts of the 8.0. What I'm going to do in this presentation, I'm going to focus on a few different things. I'm going to go on a history of the contract, where the 8.0 came from, sort of how it originated. And then I'm going to mainly focus here on the key changes between the 7.0 contract and the 8.0. And then we'll give an overview of key takeaways. I am going to focus on a few things with the 7.0 and then things that did not change and stayed the same. So I'm monitoring the chat. I'm kind of running through it with Steve here. And if you have any questions along the way, just either raise your hand, speak up, or I'll be happy to address it. Just a small bit of history. The multi-board contract has been around forever, and it started at 3.0. It started in like the 80s and the 90s, started from a 3.0 and then worked its way up. I got involved in this when I got sworn in 09. I think it was a 6.0 at the time. And then it went, for those of you guys who have been doing this long enough, went to 6.1, 7.0, and now here we are. There's been multiple meetings, and just so you guys understand, I'm not an attorney just teaching you guys about the 8.0 and what I've had from a secondary knowledge standpoint. I was on the drafting committee. So I was one of the participants to say, I was one of the participants to decide what was the input to go in. We had multiple meetings over 7 months. And during those meetings, what kind of changed everything was the NAR settlement. So we had to account for that NAR settlement and bake it into this contract, which of course we did. So 7 months later, it's going to be full tilt next week for you guys. It's going to come out February 1st, and you will see that in your MLS. So for the drafting participants, and the one thing I wanted to tell you, Steve, about just with the 7.0, the 7.0 contracts used in a lot of different places of the state. So when we negotiated this contract and when we thought about what the changes were needed, the changes that needed to go in, we did so through the lens of a lot of different associations. So we have, Three Rivers Association, Ogle County, Grundy County, and in doing that, we had to take into account how every local network's a little different than the Chicagoland network. So it's governed, the contract is governed by a joint venture agreement, and it's copyrighted. So in order to access it, you have to do so through the MLS or through one of those local associations. To kind of point out how I became involved in my role as the vice president of IRELA, I was appointed to this committee. So on the drafting committee, we had about 25 people, about 10 of them were attorneys, and only 2 or 3 of us were what I would say high volume practicing attorneys, doing more than quite a few hundred transactions a year. So when I participated in the drafting, I did so through the lens of how can I best represent my buyers and sellers, and how can we make this as easy and streamlined for brokers as possible. One of the things that we said for brokers is we wanted to make sure that with brokers is get rid of some of the initialing, not turn an already 13-page contract into a 40-page contract. So that was one of the main objectives and goals that we had. And I think that when you guys review that, you'll find that we really accomplished that. For those of you that are in the crowd, I wanted to note that a lot of people were saying if they move their seats forward, they can hear me better. So if for some reason you can't hear me better, get yourself in the front row and maybe that'll be helpful for you. All right. So after 6 months, what are the final results of the drafting process? And I'll tell you what my goal was and what we've accomplished here. But I wanted to create an easier, streamlined contract that's more appropriate for 2025 and our current market. By streamlined, we wanted to reorganize some of the paragraphs. You'll find from the 7.0 is things are all over the place. Like Where's the as-is inspection paragraph? It's in 36. Well, why is as-is in 36 if, inspections are in 12? So we really cleaned that up. We also added in that buyer brokerage compensation paragraph. We changed the practicality of the personal property paragraph. We have dealt with solar panels, not extremely well, but I'll do a detail of explaining that. We did a greater clarity on the meaning of as is, and then we allowed for better creative deal flow by streamlining and putting all the inspection and as is paragraphs next to one another. We ended the contract with enhancing the cancellation of the prior real estate contract. And for those of you that are in areas of Illinois that don't regularly use an attorney, we created quite a few addenda that you guys will use. Some of it will be used in the Chicagoland market. Some of those addendas, some of the addenda will still be used, but I wanted to make sure that we run through that for you. So if there's any questions before I kind of jump in, just let me know. Otherwise, I'll tackle it right now.
Cool, Adam. Yeah, just keep plugging along, man.
All right, let's go. So here's the first page. And the first page that I want to show you is what brokers need to know. I'm going to focus a little bit on what did not change. And I think that that's really important to focus on what didn't change, because the revamp from the 6.1 to 7.0 did a great job, and they cleaned up a lot. Lines 1, 2, 3, really simple, but you can spell out your buyer name, seller name. Steve, this is really important with the land fraud thing that you just talked about. It's always a good point where if you have somebody that says, hey, I want to sell my vacant land, and you're worried about fraud, get that seller's name right away. If you're unsure and you're running it through Fraud Safe, I would contact Tim Wheeler, have him look at who is actually in title. And my office has access to title databases, so we could easily tell you who the seller is. But that's just a really important point when filling out the contract, because we do have information to get you the proper seller names. Sometimes that's not accurate. Lines 5 through 11 lines 5 through 15 are really good, because this spells out if a property is a condo, if a property is a townhouse, single family, all that's right there. And unlike the car contracts, it's self-explanatory. You don't have to specify and use that specific car, single family, car multi-unit, car condo. You can, those are still very good contracts, but you certainly can use those. But those are one of the things that I really like about the 7.0. What I also like is we spelled out the purchase price, credit at closing, and earnest money. There's only minor changes to the earnest money, but you shouldn't have to worry or focus about that too much. But I had some questions on there. If you have questions, let me know. Home warranty is still kind of there. It's on the front page, but it's not the most important detail that you're going to see with a home warranty. So we kept that one on the back end of the contract. Seller contribution is far and away the most important paragraph for you guys. What this does now is, instead of having to use that rider or addendum as to the seller contribution, it's immediately spelled out into this contract. So on the face of the contract, we now know and indicate, and this is one that we left the initials on because it had to stay. This is you must initial this paragraph. But what this did is it's going to directly spell out the contribution. What is seller going to pay? If Adam clicks on the megaphone icon, that should help with the audio. I'm going to try this megaphone.
Yeah, it's next to the microphone. Right,
I got it. How is that?
Just keep talking.
No problem. I'll keep talking. But
oh, that's better. Yeah, thank you.
Oh, good. The seller contribution then is the most important, because now it's going to spell it out. And how is it going to spell it out? You can do it by percentage price. You can do it by dollar amount. And then, of course, we had to include, if the seller's not going to pay any buyer's compensation, we had to include that paragraph. Why? Well, we didn't want to have realtors, brokerages, et cetera, getting the same antitrust issues that the government found that was existing before. So we do give that specific option. Makes sense?
Yeah, choices. I mean, that's the big thing within our settlement as well. It's giving sellers choice around the compensation and buyers choice, and so that really makes the choice very apparent. So that's helpful. Yeah,
that's right. It's not choice. It's about disclosure and what take the settlement for what it is, but the main thing is knowledge, and do they know what they're getting into? I think that this does an amazing job of clearing that up. The seller is either going to initial it or not initial it, and now it's. I always thought it was clear before, but now it's explicitly clear of what they have to pay and have to not. One of the things that we have now, you can kind of see this, but fixtures and personal property at no added value. We moved all of the fixtures to the second page, and we are in the finalization of formatting this. It's quite possible that 42 and 43 on the final 8.0 contract might be at the top of the second page. But here's what we did. And I think it's important really quickly before I go there. It says at no added value. So you guys know, if anybody, does anybody know why we have it at no added value? It's a tax issue. So when you have a purchase price of real estate, what the contract does is it defaults that none of the personal property is being sold separately. So you don't have a house that's 500 grand and you're buying a stove at 5 grand. And that gets into some sort of taxable issues from the state because you're paying state, county, and sometimes local transfer taxes. So that's why you see it at no added value. It's included or lumped into the purchase price. When I say we streamlined this, we cleaned up most of the personal property to account for what we're seeing in the Chicagoland market. So what am I seeing over the last few years? Interior security systems, smart thermostats, your Ring doorbells, video speaker systems. We added all of that. Now, because this contract's used all over the state, there was other personal property that we had to include for the benefit of, Kankakee, Ogle counties. So what you'll see is you'll be like, well, why is there a propane tank included on here? It's not for what's attached to your grill. It's for a large propane tank that they're going to have to prorate the propane within it. So those are some of the things you see, but you'll familiarize yourselves with that and it'll make it a lot easier. The financing provision. Oh, here we go. So sorry, I didn't mean to gloss over, but we have alternative energy here now for the solar panels, and that's a completely separate paragraph. I've done probably 10 solar panel transactions, and that's more than most. It's not very common here in the Chicagoland area to have solar panels, and every one of them was messy. And do you guys, any of you guys know why solar panels are so difficult? Nobody's speaking up, but I'll tell you from my experience, it's because people don't know what they're getting. Yeah, somebody said leasing and the rental and ownership. Yeah, and it reminds me a lot of like timeshares. People think that when they buy a timeshare, they got some greasy salesman that's telling them like, oh, you get this, you own it outright. And then they get in it and it's not really the case. And that has been my experience with a lot of my clients that are selling a property that have solar panels. They think they own them. And, unbeknownst to them, until we really dig into the paperwork, they don't have a clue what they have. And it's, the leasing, the lease options, and those sorts of things. So we did our best to capture that. I do want to focus on one part of this contract, and this is really important language that hasn't changed. So when you're having an attorney review letter done and you represent a buyer, a lot of attorneys will say, oh, hey, we want a representation that, especially last week when it was -5, that the air conditioner or the condenser works. And we will respond to that, but a good attorney that knows this contract really well, it doesn't need to be put in. And what I mean by that is it's already accounted for within this contract. So here's what you need to really know, and this isn't new from the 7.0, it's a little bit of an overview, but the seller is fixtures right here, fixtures and personal property. And I'm just going to open this 8.0 because it's a little easier to see. I hope you guys can see that. But it says all the fixtures and included personal property are owned by seller and the seller's knowledge are in operating condition on date of acceptance unless otherwise stated herein. And here's what you're doing. You're going down here and you're disincluding certain items like, hey, my grandma wants her chandelier. Sometimes you see curtains or things that they're taking with them. And then what the seller's doing on every single 7.0 and now 8.0 contract, the seller's warranting the buyer that all fixtures, systems, and personal property included in this contract shall be in operating condition at possession except. And that's when you write something in. Hey, the dishwasher doesn't work. Hey, I know that, there's a hole in the ceiling, something like that. But right here, where certain attorneys will say, hey, you have to add in a paragraph. I represent that the HVAC is functional. You're already doing that. That's a fixture, system, and or personal property. So that's just kind of a notice for you guys. The other thing that's always been here, 7.0 and this 8.0, is the operating condition statement. It performs of the function for which it is intended, regardless of age, and does not constitute a threat to health and safety. You've probably noticed that language in the inspection provision, but it's really important because this is a representation and warranty that sellers are making. So what does that mean? If you're a listing agent, you should ask the question, hey, is there anything that we should list that's not working? 2, the attorney that you're working with should be asking their seller certain questions that relate to this to sort of cover their behinds. So what our office always does is we have a very detailed engagement letter, and then we have a client questionnaire where we ask a series of questions here to better protect them. And if we see something that's flagged, we're going to raise that through attorney review to make sure that they're not, that doesn't get them in hot water after the fact. Any questions there? Okay. Financing. I'm going to touch on this, and I'm just going to focus that there's not much that's different. So what we changed in the financing paragraph is we allowed for other options for different loan terms. So if you look here, now we have different terms. So if you have 2 loans, you can still select fixed, adjustable, conventional, etc. And then what we do is we add, if there's PMI, we add the amortization for years, and then we add the discount points. And then we have secondary financing. So a lot of times you'll see, like, especially back in the day, a lot of 90-10 loans, or a lot of, in certain areas, we're still seeing a lot of grants. This is where they can specify it here. The good thing is we didn't change any of the dates. It's still going to auto default. So on a 7.0, if you guys were familiar with the 6.1 or 6.0 or the car contract, you're never going to have to write in the date for financing. It's going to default. So that's really easy for some of the attorneys, but right now it's just going to automatically default to the 45 or 5 days before closing. The closing date's long, like over 60 days, it's going to default from 45 days after date of acceptance. If the closing's more routine, like a 30-day closing, the financing provision's automatically going to be that 5 business days after. Make sense? Great. The other thing that we didn't change is we still allow for cash is king, and cash with mortgage allowed. So this is a huge revamp from the 6.1 to 7.0. 1, you can make a cash offer, completely strengthen it, and you're saying, I am not obtaining financing. Of course, if you are a listing agent, you're going to want to see proof of funds on that. And then C, or Charlie, we still allow for cash transaction with financing allowed. And what this says is I'm turning Earnest money hard from day 1. I still can go get a loan if I want to, but I'm not obligated to. And if that loan doesn't consummate, or if I'm unable to do it, I as the buyer, I'm ready to pony up and play with cash. That's all that means. So it strengthens the competitiveness of any buyer offer when you have B selected or C selected. Any questions there? Okay. The other thing I'm going to touch on is homeowners insurance. We don't see a lot of changes in the homeowners insurance or the flood insurance paragraph, but I wanted to touch on something that Steve said when I joined, and he said homeowners insurance is going up. He's absolutely right on that. And here's the thing. This paragraph says the homeowners insurance is contingent upon the buyer obtaining evidence of insurability at standard premium rates. So what does that mean? This contract doesn't define that, but it's important for you guys to know that if a seller's ever had any insurance claims, it's no longer the philosophy that the insurance claim just stays with that person. It now assigns to the property and that person. So standard premium rates, one of the questions we get asked a lot is, should we get a clue report? You certainly can, but we're going to detail that for all of our buyers and sellers in attorney review. If I have a buyer, we're going to ask if there's ever been any insurance claims. And if I have a seller, in that questionnaire, we ask them up front so we can navigate it and talk about if we need to amend this paragraph, or if we need to know that the buyer has potentially an opportunity to get out of the contract under this insurance paragraph. Same thing with flood insurance. I'm not really concerned about flood insurance just because it has to deal with a special flood hazard area. And we're going to know up front, or you should know up front, if the property falls within that. How you're going to know it? Your seller's going to know if they have to have SFHA insurance, and the seller's going to have to put that in their real property disclosure report. Jump here. And then we're going to jump into the tax proration paragraph. So as a recap, there's nothing different in paragraph 12 and 12A. Cleaned up a little bit of the language about association fees and how we use that term. We just did it more consistently, but prorations still survive closing. If you're a listing agent, you should always ask your clients what exemptions they have on the property. A couple reasons for doing that in the Chicagoland market, especially in Cook County. Many times I see sellers that do not have a homeowner's exemption on the property to which they're entitled to. I think that that's really important because if we have that, if we know that up front, we can apply for what's called a certificate of error, get them that homeowner's exemption and reduce their prior tax exposure, but we can also reduce the amount of the credit that they're going to give to the buyer at closing. One of the huge things that this contract did, and we'll see if it gets caught or not, but we moved paragraph 23. We moved paragraph 23 to 12B. And I don't know if any of you guys have ever seen paragraph 23 of the prior 7.0, but it had to do with improved property or improved real estate. So a lot of times with small builders, they'll put a new construction house on it and they'll use a 7.0 contract. I would never counsel any of my builder clients to do that. It should be a custom contract. And the reason being is this 3% improvement. Most people miss this, and a lot of attorneys that are representing, onesie, twosie new construction builders will miss this. But what this does is this says that 3% has to go into escrow for tax reprorations if we know the property was improved. So if you think about that, if there's a new construction house that's, $1 million, the seller, if they don't change this, they're obligated to put in 30 grand into escrow to make sure that there's an accounting performed when the full tax bills come out. So super important, moved it over here. It should be a little bit more streamlined now where people are taking notice of that. All right. Yep. Other times that you can think about this from an improvement standpoint, additions to the property, any work that they've done that they've pulled permits on, those are things that could improve the real estate. All right, attorney review. I'm not going to spend a ton of time on this. Can you put the contract file? This is difficult to see. Yep. Somebody said, can you put up the contract file? Yeah, there's a link to this in the chat that you can see too.
I think what they're saying is when you jump over to the contract itself, it just makes it easier for people to, so jumping back and forth is super helpful. But we have a question in the chat. On your prior screen, it said same language, shorten AI. If you could kind of expand on that.
Sure. Not really anything that, if the only time that this is going to be relevant for you guys is if you're in a jurisdiction or area that's not using an attorney. But the contract for homeowners insurance, of when they need to obtain it, it's 10 business days after date of acceptance. In my experience, most attorneys are amending this now, paragraph 9. It used to be paragraph 13, but they're amending it to say that the insurance clause shall run alongside the financing contingency, just so there's a greater opportunity for a buyer to get that, because most folks don't get insurance until the end of a loan. Make sense?
Yep. You got to get that insurance now. Let's see, and get the quote earlier than the process. Kind of like what we talked about in the meeting today.
It's a great point, and I would say a couple of things. Like one of the things that I do every year, and I own a few properties, but one of the things that I do is I shop my insurance every year. And it seems like when I wasn't doing that, every 3 years I would have a huge swing. And it would go up, 25% with no claims, nothing different. So one thing that I tell everybody to do is, 1, shop your insurance claims. And then 2, if you've helped a buyer, purchase a condo in Chicago, especially in the 1 to 3 flats in Bucktown and all over Lincoln Park, or in, the 2 to 6 buildings, is shop your building insurance every year too. Most of those folks, and that's a good lead source for you guys to reach out to prior owners of condos. You could say, hey, insurance is going up. I just wanted to make sure that you're shopping your condo policy, but you're also shopping the building insurance policy, because most of those buildings are self-managed, the 1 to 3s or the 2 to 6s. And most of those insurance premiums and policies, they fall in the gap range. Like some are done by residential, residential insurance brokers. Very seldom are they done by commercial brokers, but there's usually a good opportunity and margin to lower the building's cost as well. So
that's a great point, Adam. Hey, hopefully everybody heard what he said, right? This is a great touch point for your past buyers in, those 1, 2, those condo units and 3 flats or 2 to 6 units. Reach out to your prior buyer and say, hey, checking in, with all the things happening with homeowners insurance, have you shopped the insurance on your building lately? And again, it's just an item of value to reach out to your client, your database, to talk about. So Adam, it's a great suggestion. Hadn't thought about that. Thank you for that.
Yeah, we do it all the time. We send it out every year. So what my office does is we don't really bother our clients too much because we don't want to get deleted. But a few times a year, we'll send out very important notices, like make sure that you're filing for your homeowner's exemption, especially in Cook County where you have to renew it when you sell a property. And then we're also sending out notifications as to insurance and to shop and a few other things. So just certain things. And with our brokers, we're sending that to brokers that we work with too, so they know to blast it out as well. We went through the tax change and the movement of the paragraph 23 for escrow, and then attorney review. We have no changes here, but I want to reiterate the importance of attorney review because some folks miss this. But there's the structure of the 7.0, now the 8.0, as opposed to the structure of the CAR. It's very different. The CAR contract doesn't have an auto terminate provision, but here's how this reads. 1 to 5 days, 1 to 5. Either party can propose modifications to the contract. Either party can just say, approve this contract. I'm approving this contract. I'm not making any changes. And then you can disapprove the contract, which means the attorney can terminate this contract within 5 days, so long as the termination is not solely based on purchase price. So what that means is if you're a seller and you have an offer and a second offer comes in that's higher, you can't terminate just for that purchase price, but you can terminate for purchase price so long as it is so long as there is another contributing factor to your termination. I like this closing date better. I like these financing terms better. I like anything that's non-discriminatory better in conjunction with the purchase price. So that's day 1 through 5. Now, if modifications are not waived and they're proposed during 1 through 5, day 6 through 10 is what I call the cooling off period. This is the good faith negotiation where neither party can terminate the contract during this time. So what does that tell you is if I'm a buyer's attorney and I submit modifications in day 1 through 5, and then day 6 through 10, the seller can't auto kill it. I have the right to waive or remove any of my requests. Tells you when you're talking to a client that, if you ever get ghosted by a seller or seller's attorney and they're not responding, I would tell my client that there's a high probability that they're going to wait for expiration of 10 business days, and then they're going to terminate this contract. After 10 days, auto defaults that either party can terminate. And in doing so, once that termination letter is done, it's absolute. There's a question in the chat and that I'm going to answer, and I'm going to switch over to the 8.0 language so you guys can just see it. And the question is seller attorney required to provide a reason for termination? I've seen many just say attorney disapproved and cancels contract. That's correct. There's no reason right here that allows or specifically states what a seller's attorney must disclose what they're terminating for. When I draft termination letters, and I did one yesterday, unfortunately, I always spell out that I disapprove this contract, and I just copy this specific language. And such disapproval was not based solely upon the purchase price. And 2, I let my clients know that they have to have a legitimate reason other than purchase price that is non-discriminatory that allows for them to disapprove this contract. So what could that be? That could be, I like this closing date better. I don't like the fact that, that I have an as-is clause. I have an as-is clause checked. There's lots of different things. But the important thing is when they relay that to me, they know it's not based solely upon the purchase price. Hope that makes sense. All right, now we're going to get into sort of the meat and potatoes. And this is one of the biggest changes from the 7.0 to the 8.0 contract. And that's the inspection and the as is paragraphs. So here's the thing. As is and inspections are mutually exclusive. They always get lumped together. And in my experience for, doing this for 15 years, is most agents would tell their clients, okay, we can submit an as is, but if something comes back health and safety, you can still raise it. And that was never the most accurate statement. Many times when it's as is, it meant as is. And the important thing about as is was amending that language in the fixtures and personal property that I stressed, that you don't have to put the HVAC in the letter, it's already there. That was the main point of as is, and that's what it amended. But it was a goofy contract, right? Like the 7.0 had inspections at 12. They had as is in paragraph 36. They had well and septic in the middle towards the end of the contract. It was just really goofy. So what we wanted to do, and one of the big things that the attorneys pushed for, is we wanted to streamline this contract, and we want to make it not only easier for agents to complete, we want to make sure that the sellers and the buyers understand all the paragraphs. So we clearly define it, we put them in working order, and then we give the parties certain options for inspections. And then we tagged on the other things. We put the wood destroying insect, that's the termite inspection. We put the well and sanitary right next to each other. And then we have all this right here. So I want to get into it. And I know that this is kind of on 2 pages to spell it all out. So I'm going to open the 8.0, but so you can see it. All right. So the first thing that we do here, we spell out as is. And again, this is one that's going to be initialed. All that as is the seller is making no representations and warranties. So I'm going to highlight this for you guys and I'll come back to it. But remember lines 65 and 66 that I stressed for you at the beginning of the contract? And I said you don't have to put in that representation about the AC functioning. That's because that's right here, right? A system shall be deemed to be in operating condition if it performs as it's intended. And you go back up here. Seller warrants that all fixtures shall be in operating condition. Seller represents and warranties here that everything's in operating condition. This is the point of as is. Seller's saying, figure it out yourself. I'm not making you any representations whatsoever, except for those in a different paragraph, which I'll go over. And those are seller representations and the real property disclosures. But basically the seller's saying, do your own homework. It's not on me for you to tell me if my stove is working. It's not on me to tell you if the AC is working. And I'm specifically not representing or warranting any of that. So what does that mean? Sellers markets, you're going to see this box checked a lot more. A lot more buyers are going to come in, as we've seen the last few years in Chicagoland, with as is, no representation or warranties offers. So what does that mean here? That means that you can still have inspections. As is means I'm not telling you anything, do it yourself. And then paragraph 15 says, what about inspections? Well, now there are 3 options for inspections. The first option is you can waive it. Super, super competitive sellers market, bunch of offers on the property. What could we expect to see? It's possible that they'll mark as is and they'll say, I'm not even going to have an inspection on this property. I have a ton of investors that do this now. I have investors that I work with that are buying single condos. And what they do is they don't care. They're familiar with the building. Maybe they already own a condo in the building. They know the risks. They're going to come in and they're going to submit an offer that says it's as is, and I don't care about inspections. If you got a first-time home buyer, the probability of this paragraph being marked, it's going to be too much for them. You're not going to have that same savvy investor that's going to do this, but you have the option. You have the option to strengthen your offer by making it as is and waiving inspection. Paragraph B is the same thing that we've always seen. As is doesn't matter. If they mark it, so what? But the inspection says I have the right to inspect and I can submit requests. Now, here's something that I want to stress on. Sometimes the agents say, you can always submit for health and safety. Well, the inspection request technically says you are allowed to inspect the following, and you can only raise something if it's defective. So here's what it says. The request for repairs shall cover only the major components of real estate: heating, cooling, plumbing, well, walls, doors, ceilings. And it says a major component shall be deemed to be in operating condition, same as the language above, and therefore not defective. It doesn't constitute a threat, health, or safety, and performs as it's intended, regardless of age. Now, here's what we see all the time raised, but you're not supposed to. Minor repairs, routine maintenance, painting, decorating, cosmetic nature that do not constitute defects are not part of this contingency. Do we see these raised all the time? All the time. I mean, I have modification letters on my desk right now that are going to have this language in it. My office's practice is to amend this paragraph, to remove this language, and let them raise anything. So, do a quick overview again. As is just means as is. Inspections, you can waive it. Inspections, you can raise it and bring material defects. And then last but not least is we have C, Charlie. You can still have an inspection with no requests. And what does that mean? That means take it or leave it. That means I'm going to buy this property, and I'm either going to cancel the contract because I don't like what was disclosed in inspection, or I'm going to move forward without making any requests. So when do I see this done? Again, sometimes investors or people that are in a really competitive offer, they're going to do this. What I see happen more often than not is this paragraph and the 7.0 would be checked. This paragraph would be checked, and then people will not do take it or leave it. They'll try to amend this to raise inspection. What my office's practice is to not put somebody in default or in breach, like a buyer in breach of this contract. If I have a right to inspection with no requests checked, I'm going to call the attorney on the other side. And I'm going to have a conversation and say, hey, as an inducement to not terminate this contract, I want to submit requests. And 9 times out of 10, they're going to say, okay, send it over in your letter. Send it over in your letter. And when they do that, when they do that or allow me to do it, we're basically amending this to change it to 12B, right to inspect with requests. Okay.
Adam, we do have a couple questions in the chat. Mr. Abrams, if they don't cite any appliance or system on lines 65 and 66 as not operating properly, and they check off as is, does that override lines 65 and 66?
Steve, great question. It sure does. So if they don't check off anything that I don't know in operating condition and they fill in as is here, that's absolutely what it means. It says the provisions of paragraph 7 is set forth on line 66 do not apply to this contract. So those representations are removed from the contract and it's as is. Buyer has to move forward. The only thing that I will tell you is different about that has to deal with certain material defects is how the seller is completing their real property disclosures. So they may still have to disclose something in the real property disclosure report, but as far as this is concerned, the as is paragraph trumps over those lines. Yep, great question.
Next question is, what about mold in the attic? Is that not a major component?
Well, that's the thing. Here's what I will tell you about mold. It's kind of a farce. And what I mean by that, I don't mean to undermine the existence of mold. It's a legitimate concern, absolutely. But what I mean by that is a lot of times I get an inspection report from a generalist. You know, an inspector, a licensed home inspector is not, it's kind of like, you know, a licensed home inspector to me is like your general practitioner in medicine. You know, he's going to tell you just keep an eye on it, or he's going to tell you to go see a specialist. He's not going to have, you know, the expertise. So what he's going to do is he's going to raise a bunch of stuff in the contract. And if you remember, like 5 years ago, people were unnecessarily using a mold disclosure in Illinois. Remember, like with the real property disclosures, you'd see radon and you'd see mold. People were doing that before they ever had any type of mold testing. So I have a file right now where it came in Friday, attorney review letter, and the guy said that there's mold in the attic. And I said, okay, is there mold in the attic? Show me the mold test. And he's like, oh, well, we don't have one. We just have a page from the report that, you know, the inspector says he thinks it's mold. I'm like, well, how are you going to say that there's mold if you don't have that actual mold test? to answer your question, what I will say, what about mold and attic? It's not a major component. So I think what you're saying is, from an inspection provision, can you raise it? Well, sure. I mean, I think it says right here, if it does not constitute a current health or safety and performs for the function for what's it intended. So request for repair shall cover only the major components of the real estate, limited to roofs, there you go, walls, there you go, ceilings, there you go. So can you easily make the argument that says, I think that there's mold or discoloration, is that a material defect? Absolutely, you can raise it. And again, most people are going to raise it anyway. Most attorneys will disregard this sentence, the minor repairs routine maintenance, without amending the contract. So if we got that from the seller, it is something that I think should have to be addressed. Hope that helps.
That's helpful, because Adam, keep in mind too, for us, we're all throughout the entire state of Illinois, so we do have a lot of agents who work in areas that don't use attorneys, and so
yeah, for sure,
these issues have to be addressed. So.
And there's a good way to do that, not an attorney review. It gets a little trickier when you're in those areas, and someone, if they're not using attorneys on other side and they're not taking advantage of the attorney review provision, deadlines are more likely to get, potentially missed, or people can become more difficult and stick to the letter of the contract without utilizing that modification provision. But that is in the addendum and rider, which I'll show you how to properly use that.
Question in the chat: is there a section for FHA or VA inspection issues?
Kind of. It's not VH, and we're kind of segueing into the next part. So you can see we have it all right here. You're not going from 12 to paragraph 36 to going back to the 20s. 14's the as is, 15's the inspection. And just a quick overview, there's 3 options: waive it, have inspection and make requests, have inspection, no requests. And then right here, we dump in the VA FHA stuff that you see most common, and that's the wood destroying insects. And we wanted that right there, right? I mean, it makes more sense than to have the agents and the attorneys hunt for it. But right here, we say additional inspections. Wood's still there. And what we did is we have this initialed where it is the seller's expense. And that's because the FHA and VA require that. They say a buyer cannot pay for the FHA termite inspection. So that's why we still have that there. They have 15 days to do it, or they can have an old one. Sometimes when you list a property that's commonly in the FHA area, they may have a prior termite inspection. Weller sanitary's right there too. We still have that. That's more common in rural areas or unincorporated areas, but it spells everything out all right there. And that's the seller's expense. Any questions? Okay. Once someone asked, is there a section for FHA VA inspection issues? And I touched on that just as to the termite, but what I will tell you is there's not a requirement for an FHA. And I think what you're referring to is when the FHA appraiser comes in and says, we require reconciliation. And that's not in the contract, but that's a financing contingency. So pursuant to the terms of financing, if the lender's appraiser is going to require reconciliation, the seller will be obligated to perform those repair requests. And if they do not, then the buyer has the right to terminate the contract based on the financing contingency and get all of their funds back. So that was to Donald Beard. I hope that makes sense. What we always do in our letter is we add an appraisal contingency. And you can also add an appraisal contingency if you're in a rural area. There is a new addendum, and there's an addendum that I don't use very often, but in the Ogle counties and the different parts where the 7.0 and now the 8.0 will be prevalent, but there won't be the prevalence of an attorney being used. Pay attention to that rider if you're in one of those areas. Hope that helps. Okay, minor modification of the HOA paragraph. We had some language where on most of the deadlines in the contract, we had after, right? Attorney review is 5 business days after date of acceptance. Financing is 45 or 5 days after date of acceptance. And we had this goofy language that just said from. So we just cleaned it up, streamlined it. From became after here to avoid confusion. No other significant changes in the HOA paragraph as to when docs need to be ordered and submitted. So I won't bore you guys with that. What I will tell you is these minor changes that we made are super important. As we were talking about inspection and as is and all that, you still have seller representations. And what used to be, we initialed everything. So if you remember before in the 7.0, you had like has not, are not, has not, all those things that you guys had to initial. So we removed that and cleaned it up here. But I will tell you, seller representations are one of the most important things that people get sued over. And that's because this seller, every seller in every contract makes certain representations to the buyer, and the as is language does not amend this paragraph. Okay. That would be a separate rider. My background, not to bore you, but before I started my own firm, I got sworn in 2009, and I was a baby lawyer. There were no jobs. It was either do bankruptcy, do foreclosure, or do something else. So I started at a foreclosure law firm, and I worked my way up from just regular counsel to a managing attorney there. And one of the things that I learned a lot was from an REO transaction, how good and how detailed their as-is riders have to be. So what I'll tell you here is every single mom and pop buyer seller, every investor that uses a 7.0, now 8.0, they make certain representations. Scary part about this is sellers' representations contained in this paragraph shall survive the closing. That means it doesn't merge into the deed, and that means we can that means we can sue afterwards. So seller represents that with respect to the real estate, seller is not aware of anything. And here's the big one. It's usually H. Any improvements to the real estate for which the required initial and final permits were not obtained. So what that means is if you're in the burbs and you're selling a house and mom finished her basement and she didn't pull permits, they're in violation of this. Seller can go sue them anytime if they discovered violations after the fact. You renovate a property, you put a new bathroom in, you change the floor plans, you update your kitchen. Those required permits and you didn't get them, you're in violation of this paragraph. It's what we see the most often. I'd say city, for you city brokers, most common is roof decks. Someone's going to put in a new roof deck and they're not going to pull permits. Really important now, especially that these aren't initialed, that there's a conversation up front. We had a big, lawyer debate on changing this language. We changed has no knowledge to is not aware of. And that's just a legal terminology as to, constructive knowledge, constructive notice, what you should be aware of. But as to this paragraph, if you have a listing, you should ask your sellers, you walk into a house and it's an updated kitchen. Did you pull permits? Were they required? Good questions to ask. My office in that questionnaire, we ask all that. And if I find out that there's anything where they didn't pull permits, it happens all the time. It doesn't need to be a deal killer. It happens all the time, but I amend the representations in attorney review. So somebody asked me that. It says, how do you protect the seller from the list in paragraph 24? It's really simple. If I have somebody that I know that finished their basement, and I've been fortunate enough to sell my parents, be the attorney on my parents' house, on my grandparents' house before they passed. And, you kind of know, but I'll amend that representation and I'll say, in 2010, the seller finished their basement to the best of their knowledge. They relied on their general contractor. They don't have information. They don't know if permits were pulled. Buyers shall do their own due diligence. And we amend our representations in paragraph 24 commensurate with the disclosure in this letter. And that usually gets you done. If you're doing something like if you're representing guys that are flipping properties, gets a little different. And with every one of my sellers that's an investor that's flipping properties, they're all different. Some want a very detailed as-is rider, which I've custom drafted for them. Some want to just say we didn't pull permits. Some want to disclose that not even that, and let the seller representations ride and roll the dice. Which we counsel them and get a letter of recommendation you disclose that. But it's kind of all over the place. So Humberto Manzo, that's how I protect my sellers. I ask the questions, and once I have that information, I'll know. Susan Pierce, 100% right. Like, not all cities require permits, though. It's very true, and not all counties, depending on what location you're in, require permits. It's very different. So it really depends, and it's municipal specific. Let me go back up to some of these other language we have. We have a lot of questions there. Sure hope all brokerages are training their people.
Yeah, I think some of we got. One here, Don, does line 279 refer or include village pre-sale inspections? I guess for pre-sale.
No, it's a different paragraph. It's not within the that 279 falls on the common interest community associations, but that is in there. It hasn't changed. It's in the 7.0. It's a different paragraph for municipal. Here, I'll show you right here. So to answer your question, just review 19 line 304 to 306. Cost of transfer tax and inspection fee and any repairs required by an inspection pursuing minimums shall be paid by the party designated in such ordinance unless otherwise agreed to by the parties.
Great.
So if you're asking me a question and that's kind of a specific question that I see happen, let me go back up to how it was phrased. Does line 279 refer to include village pre-sale inspections? The answer is no. And what I would tell you is the seller's obligated to perform under the terms of the contract and the closing date, just like the buyer. So they should know when to order those. Village inspections are pretty easy, right? And what I mean by that is when you get a listing, if you're in an attorney area, I order them when we get a sale right away. And the reason why I do that is even if this deal cancels, if they're going to sell the property again, we have to know what the municipality is going to require. So do I see delays with this? Of course. I mean, I do deals in Berwind and Cicero too. You know, I know how challenging some of the municipal inspections can be, but it's super important for you guys to do that right when you list, or at least notify the attorney that they're going to work with to do it right when they list.
Berwin. Another question, situation from Ron. How do you protect the buyer then on the flip side? Because I'm imagining you're referring to section 24 there. But I guess it's just more a matter of negotiations, right? Between, you know, if you're in an area that uses attorneys, between the buyer's attorney and the seller's attorney on that section.
Well, it says, how do you protect a seller from the list in paragraph 24? I think I went through that. I think it's a matter of disclosure, and that is, but how do you protect the buyer from it? The answer is you do not. That if they do not disclose anything, then the protection is baked into the term of the seller's representations. Right. That's already there for them, and they are making those representations directly up front. And by signing this contract, they're saying nothing else is different. Now, I will tell you, I don't counsel people in areas that don't have attorneys. And at another brokerage training, they asked me about this, and I said, you know, technically there is a blank spot where you can do it and you can amend it, but I would have the seller draft up an addendum to the contract that outlines that if you're not utilizing the attorney review paragraph, or I'll show you later like a very small line where you can attempt to squeak it in.
Yeah, this is a huge change because this is a big area of consternation for buyers agents. Do I initial it or not, and require to and send it over, and who's signed initials, and this has always been one where our point of view is for the sellers to try to be like a cop out. Like now you can't. Like this is very clear, and then you know this is just a carryover from. And best question here in the chat: will there be an amendment or disclosure for sellers to disclose known issues regarding the paragraph? Ultimately, that would be the real property disclosure. And, you know, it's one of those things that I think sellers, it's just basically playing a game. And this is probably one of the big and better, huge changes that I'm seeing from this whole 8.0. Like this is huge.
Yeah. And I think it's a really good one to you know, to kind of bootstrap with the as is paragraph. And for all agents listening to really understand that too, fixtures, personal property, because that was glossed over a million times and it's glossed over by attorneys. Like, there's zero reason for an attorney on a 7.0 or an 8.0 contract to send me a request that the AC is an operating condition. It's spelled out in the contract. But I will tell you is with this, what we found, and understand that that the multi-board committee was 25 of us, and I spent a lot of time on this as well. And what came back to us is the sellers, and globally, especially with DocuSign, was that they were not having the conversations with their clients, or their clients didn't understand what they were agreeing to and what they were initialing. So that's the kind of the benefit that I will tell you. Like if you're in the Chicagoland market, and you're doing a lot of these deals, you should ask your attorney who's representing your seller their familiarity with the nuances of the changes to the contract, and just in general what they're doing to protect the sellers from not getting in hot water down the road. Now, it's important that you guys all understand that no matter what, you're doing that through the lens that if they violated this, what's the likelihood that that's gonna materialize to lawsuits? You're talking about 0.0001%. But when it does, that water is very, very hot. So, it's just being practical at the same time. All right, minor modification, minor changes. Let me see. Yeah, here's what I say, like just a refresher. Ask your clients, talk about renovations, talk about basements, talk about roof decks, talk about the new bathrooms, find out if they pulled a permit. If they did, awesome. If they didn't, don't let it not let you get the listing or list the property. It's just the way we clean it up at the front end. All right, Steve, this is more important for you. Does EXP hold money?
We do, yes.
All right, so here's one thing that we changed, and this is a significant change solely to benefit brokerages, not brokers. And I said, I don't think this is going to matter. I don't think they're going to release it anyway. But if you look at here, 27, direction to escrow, this is like what happens when a deal terminates. It's declared null and void, and earnest money's got to go back to somebody. Sometimes that gets disputed. But now what we did, because I've had, hundreds of earnest money disputes, and a lot of times it's people that are just angry and they refuse to sign. Even though they know the contract's dead, they're not going to release earnest money for whatever reason. So now a brokerage, not a broker, but a brokerage, if the escrowee is the brokerage, escrowee shall give written notice to parties at least 14 days prior to the date of disbursement saying we're going to disperse. And if no written objection is received, they can disperse pursuant to that. If any party objects, they can't. They have to follow the interpleader rules and the other rules of this. But that's important for brokerages to be able to just say, I can disperse and not be held liable. Are they going to do it? I don't know. I mean, that's a managing broker, brokerages specific office. But now this language in this contract does allow for them to do that. Okay.
Yeah, we already do this.
Cool.
Just kind of carry over from, IDFPR and state law.
Yeah.
We have that ability to do it, but this is great because it reinforces that ability. And for those of you that are watching, if you've got a dispute, and our team, the broker team, will send a letter out to all parties. And if no one disputes it, boom, on day 15, we're sending the money out and moving on because we want to get these off our books as well. Because
100%.
We do like 9,000 transactions last year, and so there's some money sitting on my escrow account. That
I can imagine there always is. And hey, Tim Wheeler from Chicago Title listening. Sorry, you're not an Illinois real estate brokerage. You don't get to do it.
Right.
No, but I will just say, like, it can be a real problem, and it does mirror the law. And now this is a material term of the contract that buyer and seller have signed. So if they don't pay attention and slip, then you do have that option.
Question to chat from Susan. So shift 27 is that the attorney no longer drives disbursement without an interpleader. I think that's just, again, like you mentioned, just for the broker.
Well, Susan, it really depends on it. The question comes down to who's holding earnest money. So to answer your question, I hate being a lawyer sometimes. And Tim said he works with them all day, so I feel bad for him. But it really comes down to who the escrowee is. So every escrowee is going to have their own. They're going to have their own. Standard operating procedure on following the law and how they're going to release. But to answer that, the disbursement without an interpleader, I suppose that if the attorney's holding earnest money, then maybe, but I won't, I can't answer that without seeing specific facts and who's holding and what the contract was used and what was read and how it reads.
So, like, this is Susan, Adam, and I'm going to say that, like, my attorney has started to hold the money because slight point of contention with the brokerage in that when somebody exited a contract and it could be financially detrimental to the seller, the attorneys always recommended that the earnest money not be returned until the new contract is executed and the seller is no longer harmed by the prior contract being terminated without cause. So that case, earnest money needed to be held. So I think from that point on, several of my attorneys have decided to hold earnest money so that they can better service their seller and ensure that the seller isn't being financially impacted by wrongfully terminated purchase contracts.
Well, I'll tell you, yeah, that's a great point, and I'll tell you how my philosophy on this reads, and why I do not hold earnest money in my IOLTA account for real estate transactions. One, I think it's an inherent conflict of interest, and I think it's dangerous for sellers' attorneys to take that approach. And here's why. If a buyer is in material default under the contract, and that's a difference between just default. Material default means they've breached it and they can't cure, and now you're in a position where you're ready to sue for damages, for specific damages. And my office does have a practice where if the buyer's attorney and the buyer blew financing contingency, right, they waived it, meaning they didn't timely request an extension, which is the most common buyer default. If I have something like that, I immediately serve notice to escrowee that they're in material default. They have 3 days to cure, and they can either agree to release the earnest money, or we're going to hold it. We're going to hold it in that account for damages. And Tim Wheeler will know that the only way for us to finalize those damages is to mitigate. So you have to list with somebody else. You have to have an offer that comes in that's less than what you're going to net from the first contract, or the total dollar amount means you're going to net less than, and only then are you able to quantify your damages. So the reason why I will not hold as an attorney, Susan, and why I think it's a conflict of interest is that scenario that I just described to you where the buyer defaulted happens 5% of the time in relationship to when a buyer lawfully terminates the contract, right? So if you have a buyer that lawfully terminates the contract, and I'm going to open this up and just go back to attorney review. And if you look here, it says it's absolute, right? If notice of termination is given, said termination shall be absolute and the contract rendered null and void upon the giving of the notice. So what I have had happen is back in 18, when I used to hold money in earnest in my IOLTA, they lawfully terminated, and then my seller said, no, give me the money back. I said, I cannot give you the money back. And they said, you're my attorney. I want this money. It's in your account. Give it to me. And I had to explain to them why I could not do that. And if they don't give the money back, they can sue you under the performance provision, which is my next slide, and they will win. It was a lawful termination. They're going to get their earnest money back and attorney's fees. So it became too much of a headache for me. And if you go back to that small percentage where they're actually in default, I just serve notice to escrowee, and I let the title company or the brokerage know that we're deeming them in default. We're going to call it material default, and we're going to use it to mitigate damages on the next contract. There's nothing worse than fighting over earnest money, and I feel it for agents, for brokerages, and for attorneys alike that have to go through it.
I was kind of hoping you guys were going to eliminate EMD from the contract. I know there has to be some exchange to make it solid, but it does seem to be very controversial these days.
Well, it strengthens an offer, right? I mean, it lets you know how serious they are too. But back to performance, I'll just say here, I pushed in the committee for this language. And the reason why is I wanted to broaden the scope. And we used to have language that says in any action relating to this contract. I expanded it, and this is my push to say arising out of or relating to, and the prevailing parties entitled to damages and attorney's fees. Why I wanted to broaden this is I've had other attorneys on other deals say, well, a post-closing possession agreement's a separate written agreement, it's not contractual, and you don't get attorney's fees, or an escrow holdback agreement, special assessment's not contractual. So now I took it completely out of play with this line and with this case, and then we completely expanded it to here. So now if somebody is in default and it's not just relating to the contract, but something else ancillary to it, you're going to be more likely to get attorney's fees. Home sale contingency, you guys have all seen it. There's nothing different there. I just wanted to stress the importance of filling out those terms. And then this is something that we revamped, and this has to deal with the cancellation of a prior real estate contract. Essentially, there's 3 instances, and we spelled it all out. One is the kick out of prior buyer under home sale closing contingency. So this spells out now in paragraph 32A. If you have a home sale contingency, you get a new offer, you want to kick them out, it's subject to that one being terminated. 2 is the backup offer scenario. Seller has entered a prior real estate that is not contingent. Once inspection and once inspection and attorney review is done, it outlines that has to terminate to accept this one. And then we give a little protection to the buyer for double jeopardy. In the event the buyer has entered into a prior contract for the purchase of other real estate, different property, this contract shall be contingent on notice to the buyer before that contract has been terminated. Buyer's prior contract has been terminated. That way they can't get hit twice and stuck. So you'll know it when you see it. If you have questions on it when you get there, let me know. And then here's the solar paragraph, paragraph 34. Here's what we've done. And it's not, I'll be the first to tell you, this isn't perfect. And it's not perfect because, like I said, it's kind of like a timeshare condo thing. The sellers never know what they actually have. But if we know there are panels on the property, seller's now going to be obligated to deliver all paperwork to the buyer within 3 business days after acceptance. The buyer then has 3 business days from receipt to declare the contract null and void. And then here's the main kicker. If the documents are inconsistent with the representations in this paragraph, then the buyer may cancel at any time. And this is the most common scenario that we are going to continue to see. And it's the buyer tells us one thing, and then we have to call Sunrun or somebody else, and we get additional information. Or we find out, the buyer has to go through their own credit report, those sorts of things. What I will tell you is if you're a listing agent and you know there are solar panels, get in front of it immediately and don't just take the seller's word for you that, hey, I own these panels outright, I'm getting this or that. You want to get contact information, all the paperwork, and try to get the transfer to be as painless as possible. Though I do not think in the Illinois market that that's probable right now. There's just not enough of them. Any questions on that? Okay, more space for contract addendums. This is what I was kind of telling you guys about. There's now a series of addendums, and we really tried to limit the pages of this contract, and we came up with only about a half page here, but these are the most common ones you're going to see. And then in jurisdictions where you're not using an attorney, one thing you technically could do is, you see this other, you could write in amend seller's representations, new kitchen, no permits, stuff like that. You could technically write that in there. I'll go through the addendums with you guys. No significant changes to the signature lines. It's all filled in. Make sure that every owner of the property is going to be, signing as seller. Make sure that every buyer that's going to be an owner of the property, meaning they're going to be entitled, signing that. Any questions come up, just let me know. Always, if you know it's an HOA, fill this in. And even if you don't know if there's an HOA or you don't know the specific contract, write the name of the company and to be determined. That usually cuts down on some of the time. Addendums. So there's a bunch of addendums that you can use. Yeah, I would say always ask who is on title. Celeste Barr, you should definitely ask who is on title. And then, an attorney you work with should be able to pull the vesting deed for you and tell you who's entitled. But we see that missed. My office's practices is immediately when we get a contract, I open title, I pull the last vesting deed, I see who's in it. And if I have to issue an addendum adding a different owner, we'll do that. It also tells us if somebody, if it's unfortunate and somebody's passed, we'll know that we'll need to get a deceased tenancy affidavit, those sorts of things. Tell the exact same name, father and son, they never mentioned it. Yeah. Is the as-is addenda needed if the as-is paragraph activated? No, never. I mean, you never needed the as-is addenda if the as-is paragraph 36 and the 7.0 was activated too. But I will say, if you have specific investors that are selling properties that are, they're not going to pass anything, then you should. There's certain instances where you absolutely have to use a much more detailed as-is addendum. I'll give you a perfect example. I have a property that's being sold in the north side of Chicago. That's a 6-unit that had a fire, and they had 2 fires. And we have a very detailed disclosure and as-is rider that we're using for that. All right, additional documents. I'm going to go pretty quickly here. I'm going to expand them, or do my best to expand them here so you guys can see. I only see this appraisal addendum used in, the non-attorney areas. So somebody asked about FHA, VA, that sort of thing. Absolutely use this, and that would bake in the inspection terms through the appraisal addendum to be satisfied. Amendment notice and response form. Again, these are extension addenda this is an addendum that would be used in non-attorney parts of the state that basically asks for extensions of financing, closing date, amendment of closing possession date. I don't know how to counsel real estate brokers in these areas, but they should be pretty familiar with this form. And then we have intent to escalate optional. We see this a lot in competitive sellers market, right? Escalation clauses. This is a great document that spells it all out, that we'll use it. Everything's done. We've seen this a few times. There's not that much change to it, but it's a really good streamlined document to strengthen buyers' offers in competitive markets. And then multi-unit addendum. I do a ton of multi-units. So I have a lot of investors buying and selling, and, multi-units are tricky in the 2 to 6, unit space, because you get all kinds of sellers and you get all kinds of attorneys representing those kinds of sellers and buyers, and they don't, maybe have a robust workflow for multi-unit. We have a very robust workflow for multi-units that outline what everybody should do. I see a lot of things in the notes. Will you send me these fillable forms? All these, I can't send you guys these yet, but they're all going to populate to the MLS February 1st, and they'll all be readily available in your local MLS. So if you use CAR or more or whatever, February 1st, they're all going to get released with those final forms. And until they do that, I'm told that this big draft thing, we can't use them, or we can screen them, but we can't. They're not for use yet. Multi-unit, if you're ever selling a multi-unit that's subject to tenancies and you haven't done anything, I talk to your managing broker, talk to an attorney that you work with, but I would certainly at a minimum use this addendum. And then mutual cancellation. You guys have all seen this before. This just outlines how you get the earnest money back to the seller, or back to the buyer, which is normally the case. And then if there's any other agreement to do that. I will tell you that sometimes the money goes away and then there's a problem after the fact. If this form's signed, it's final. It says that. It's hereby agreed, subject to buyer upon oral written release involved in the professionals. So once this form is signed, it's void. There's no further cause of action. The contract is null and void. They waive everything. Okay. Repair agreement. Non-Cook, non-Chicago, non-attorney areas. It's a great addendum to use when you're making repair requests. Seller, what they can accept, amounts, etc. And then reverse contingency addendum. Not concerned with this. I've never seen it. Short sale addendum. You can use this, but I haven't done short sales in a long time. I think the last one I got was 23, just because most folks have a little bit of equity, but I have a very detailed short sale rider that we draft up to. Key takeaways. I know somebody's got to get out of here, but there's a lot of good things that happen from 6.1 to 7.0 that are staying the same. You still have that automated financing and attorney review dates. Somebody asked about prorations, and I always tell people that if you're in Cook County, you should probably have an attorney look at prorations or write in to be determined instead of that 105 or 110. If you write in the 105 or 110, it doesn't matter. Like, you still have the opportunity to modify that through attorney review. But because Cook County reassesses triennially, you really want to make sure you're paying attention to what year the triennial reassessment is, especially if it's 25 or 24, because you're going to want to prorate accordingly. The other thing is, ask your client if they own or occupied the property on the first of the year, and then pull the exemptions and look at them. Our process is every single file that I open, the first thing that we do is we pull the county assessor records. We look at the assessed value, we look at the new one, and then of course we look at all the exemptions on the properties. And we do that for a buy or sell because we know we have to prorate. And we do that for a lot of our real estate agents too. If they ask us to look for listing presentations and whatnot, a lot of times they can kind of get money back if they're entitled to an exemption. New, I think this is the most important paragraph. Compensation is now right there, the seller contribution to pay. What I will tell you on this is you're still, and I'm not a managing real estate broker, so I don't know how brokerages and managing real estate brokers are going to counsel you, but I think you're still going to have to do that buyer broker compensation agreement. And I think all title companies are still going to require two commission statements now. But as to compensation and what the seller is going to pay, it's right there. I'm not a brokerage, but I don't think they're going to require that additional form anymore, the seller contribution.
Yeah, I would agree with you there. Obviously, the buyer broker agreement is required prior to showing the property, but yeah, I think that's going to eliminate that additional compensation addendum that goes with the 7.0 or the ones the car have. So yeah, we have one as well, but this basically eliminates, and other parts of contracts and other parts of the state, like in Champaign and Southern Illinois and Quad Cities, have incorporated compensation into the new purchase agreement as well. So this is a good change, because we've had situations where the compensation addendum got kind of, I don't know what the word is, got disconnected from the purchase offer, and let's accept the offer because there's no compensation addendum. They don't want a commission, and then it hits the fan afterwards when there's some confusion. So
I had a few of those in August, Steve, and we amended, just so you guys can understand my workflow. You can tell I do a lot of these, and I don't say that to be cocky. I just say that, not with hubris, but to be, let you know that we've put a lot of thought into changing our forms, and we changed our attorney review function to, when we review the contract, like our work's pretty divided up from paralegal to attorney, and we're event and task driven, but we have language in our tasks now to say, when we review the contract, do we have a compensation agreement accounted for? And we're going to keep doing that even with the 7.0 and 8.0, because I'm asking our buyer's agents if their compensation is different than what's reflected in the contract, because a lender is going to need to know that, and it's going to have to get captured on closing.
Yeah, we've actually created an invoice form that kind of discloses that. So if a seller is paying, let's say 2%, and the buyer is actually paying the buyer's agent an additional 1%, then we have an invoice form that's sent out to both the buyer, the title company, and the lender, just noticing like, hey, by the way, there's actually more money coming out, and so that everyone can incorporate that in the process. So yeah, that's a good point. A couple of quick questions in chat, because I know everyone needs to go on with their day. Steve Abrams, should we still use that seller contribution addendum? If you're going to start using the 8.0, it's going to be available February 1st, and it's going to be mandatory starting March 1st. You're no longer going to be using the 7.0. I'd say if you're using the 8.0, you don't need to use the compensation addendum. Laura, if we can talk about the as is kind of offline as we get into it. I know we've talked about that at some point, but ultimately it's the answer is no.
Depends.
Depends,
buyer.
right?
If buyer agreeing to as is, is it reasonable for them to initial the option to have an inspection, be allowed to ask for repairs? Absolutely. I mean, that you have to look at it through the lens of the strength of the offer. And what I think is going to happen, Laura, is I think a lot of times what you're going to have is the buyer is going to submit the offer, and then the seller is going to mark it as is, and then they're going to submit it back to you to countersign. I think you're going to see that happen a lot. And I think, you're going to submit an offer, and then the listing agent's going to say, hey, you know what, let's strengthen this. Let's limit your representations. Let's mark it as is. Right. And then that inspection provision, the A, B, or C, no requests, with request, no, you can have inspection, but you can't ask for anything, will probably get pared down. That's what I think we're going to see in that market. And then I think a lot of it's going to be for naught. I think we're going to see the same practice that we've always seen.
Yeah, I totally agree. All right, we're on the, we do have to wrap it up. I appreciate it, Adam. This has been hugely beneficial to our team. I appreciate you coming on. You've been a wealth of knowledge, and we're grateful. And everyone here, again, appreciate the time you invest in your business to learn more about the new contract. Again, your boards will be sending it out here on February 1st. It should be loaded into MRED and your board's websites. You can start using it February 1st, and the transition period is very short. Starting March 1st, you will no longer be using the 7.0. And Adam, your contact was on the screen. Again, we've shared a copy of the presentation in the chat, so if you need to get a hold of them, it's in there as well. Bookmark that. And I appreciate your time so very much, and hope you have a fantastic
My pleasure. Thanks for having me in your auditorium. It's just like the one I remember from high school.